that I'd like to distribute to members of the committee. And what this handout is a legal opinion signed by myself and 11 other Toronto area lawyers that says, in our opinion, the City of Toronto does in fact have the authority to implement the proposed bylaw to put an end to the consumption of shark fin in Toronto. And the municipality, all municipalities in Ontario, including Toronto, have this jurisdiction under 3 different headings. The first is animals, including their welfare. The second is public health and safety. And the third is consumer protection. And it's important to note that the wording is virtually identical in both the Municipal Act and the City of Toronto Act. And I think it's clear that this is obviously an issue that pertains to animals, and it's an animal welfare issue because of the cruelty that we just saw in the previous deputation. It's certainly a public health and safety issue because of the bioaccumulates that exist in sharks and shark fins, the mercury and other heavy metals that accumulate. And finally, it's a consumer protection issue because the City of Toronto depends on the health of the world's oceans. We consume fish and shark fins and other seafood products here in Toronto, and as a result, we have a direct impact on ocean health. So I think it's clear that under all 3 of these headings, the City of Toronto has the jurisdiction to implement such a bylaw. Now, there's been some confusion about municipal and Toronto authority surrounding the bylaw, and I think that this confusion is rooted in a misunderstanding between the jurisdiction under the former 1990 Ontario Municipal Act and the more modern 2001 Ontario Municipal Act. And under the old Act, there was a decreased level of jurisdiction pertaining to animals. Generally, the animal had to be a nuisance in order to pass a bylaw on the issue. But in 2001, and again, this wording is echoed in the City of Toronto Act, there's been an expansion of those powers to deal with animals more generally, including animal welfare. So I think the root of the confusion in the public mind has been that difference in authority from the 2 versions of the Act. And the previous bylaws that in some instances have been struck down under the old legislation, which is no longer applicable under the new legislation. Another element that is important to note is that it's been found at all levels of courts, including here in Toronto with the Court of Appeal and CropLife Canada versus the City of Toronto, that multiple levels of government may legislate on an issue. So the federal government, the provincial government, and the municipal level can all validly pass legislation, bylaws on an issue. And as long as a bylaw doesn't conflict with existing federal or provincial legislation,
thank you, Mr.
then it's valid.
Any questions to the deputant? Councillor de Berardin.
Thank you, Mr. Chair. Through you. Okay, so can you expand further on the municipality's role in environmental concerns? So all levels of government have a duty, and I think it was a Supreme Court decision on that, to protect the environment. So can you expand further on that?
There's a precautionary principle that's being stated by courts, stating that where there's an important conservation issue, an important environmental issue, but there isn't 100% proof that a certain step will ensure the protection of the environment or the environmental ecosystem, that it's reasonable and within the purview of whatever level of government is dealing with the issue to take precautionary measures to ensure that our environmental systems aren't damaged.
Correct. And then the second question is regard to the health and safety and well-being of the persons and the protection of persons under the Health Act. So can you expand further on that and mercury within the shark fins?
Well, there's been discussion that this is an issue that should also be dealt with at the federal level and should be regulated by Health Canada. And I would agree with that statement, but as mentioned, that doesn't mean that it shouldn't also be dealt with at a municipal level. And as I mentioned in my initial discussion, the municipal jurisdiction does include public health and safety. And as I'm sure we'll hear from other deputants today, there are serious health considerations in the consumption of shark fins. and bioaccumulates accumulate in shark and shark fins and pose a threat to human health. So by passing a bylaw to prevent the consumption, it falls under that municipal authority to protect public health and safety.
Great. And then my next question is, how many lawyers signed this document?
So the letter that I've passed around, and I hope that all of the members of the committee now have, is signed by myself and 11 other lawyers located in and around the City of Toronto. And we got a number of lawyers to sign on to show the fact that lawyers agree on this issue. The City of Toronto does have the jurisdiction to legislate on shark fins.
That's great. And exactly. And what would you? Why is that? What, except for our lawyers, exactly. So going back to the Criminal Code of Canada. So 445.1, everyone commits an offense who willfully causes or, being the owner, willfully permits to be caused unnecessary pain, suffering, or injury to an animal or a bird. Would you not say that that includes shark finning?
In my opinion, it most certainly does. When it comes to animal issues under the criminal code, and frankly at all levels of jurisdiction, there's often a disconnect between what's stated at law and what is actually enforced. So I would agree with you fully that that is a cruel practice and that should be dealt with by law enforcement agencies pursuant to the criminal code.
Great. And if this were ever challenged in court, wouldn't you say that most courts defer to the municipality?
Yes, the courts have said very clearly that generally speaking they grant the municipality a broad range in applying its jurisdictional powers.
Great. And great work, Nick. I love the work that you do. And you're a great advocate for the protection of animal species. Thank you.
Thank you.
Any other questions? Any other members? Okay, great. Councillor Gloria Lindsay-Ruby. Yeah.
Very interesting description here of the powers of the municipality. So my question is, why did we hesitate so long in Toronto, fearing that the municipality didn't have the power to ban this, whereas Brantford, Oakville, and now Mississauga went ahead and did it? How come?
Well, I could only speculate. I don't know the internal reasons. Nothing was put forward publicly to explain why there's that concern. It may have been, as I discussed, confusion over old powers and new powers. It may have been just a very conservative demeanor and a reluctance to take on new and important issues. I could only speculate.
But now the city solicitors of those jurisdictions, I assume, are in support of the ban.
Again, I'm not aware of any public information. I did make an attempt to get a copy of any legal opinion from the Mississauga solicitor. I was advised that it wasn't, if there was a written copy, it wasn't made available to the public and was unable to obtain the document.
So it was confidential.
That was what I was told, yes.
So, okay, thank you.
Thank you.
Thank you. Any other questions? We're in the committee now. If not, thank you, Mr. Wright.